Florida Now.
Thank you. I'm Barbara Devane, representing the National Organization for Women. Thank you, Senator Soto, for your fine amendment. Usually I speak for myself, as you well know, but today I would like to read into the record an affidavit from a lawyer who is a family law attorney. My name is Mark P. Rabinowitz, and I'm over the age of 18 years and of sound mind. I'm a licensed attorney in the state of Florida. I practice in Orlando, Florida. I am board certified in marital and family law. I served for 6 years on the Florida Bar's Board Certification Committee in marital and family law. That committee writes and grades the exams for those members of the Florida Bar that wish to become board certified. I have read all of the proposed alimony reform bills and have given testimony on 2 occasions in Tallahassee. I believe all of the current bills will be damaging to Florida families. The financial provisions of the pending alimony reform bills are all nearly identical. With respect to the ranges for the proposed alimony, both as to the term and as to the amount, there has been no study to justify the formulas proposed. When asked at a recent hearing whether an economic study had been completed on her proposed bill, Representative Burton stated none had been conducted. In my opinion, the formulas utilized are arbitrary and without financial justification. Senator Soto's proposed amendment would have cured this flaw. The modification provisions of all the pending bills are subject to attack as being retroactive and unconstitutional. All the bills state that a 10% increase in alimony recipients' imputed income from the initial award constitutes a substantial change in circumstances. All the bills state upon proof of a substantial change in circumstance that a court shall reduce or terminate the alimony recipient's award. All the bills state that this law would affect all future modification proceedings. In my opinion, regardless of the law that existed at the time that the parties entered into an agreement concerning alimony, this new law would require the court to reduce or terminate an alimony award if the recipient received an increase of 10% or more in his or her imputed income at the time of the initial award of alimony. Some, but not all, of the bills include presumptively equal time sharing provisions as being in a child's best interest. No other state has such a law. This language exists regardless of the age of the child. Infants and toddlers may be shuttled between households. No study has been presented indicating this is in a child's best interest. Equal time sharing of minors of divorcing parents has been employed by different countries. Studies do exist indicating that equal time sharing is problemsome. In closing, I thank you for permitting me the time to address you. And many times, these are my words, many times the sponsors and supporters of this bill say that it will give certainty to the law. It certainly will. It will certainly throw, if passed and signed by the governor, it will certainly throw thousands of women and their children into poverty. Thank you.